Now to a First Coast News investigation.
Tonight, a Jacksonville woman is demanding change after she was forced to appear before a judge while she was in labor.
So Cherise Doyley was pregnant with her fourth child and 12 hours into labor when a nurse came into her hospital room at UF Health downtown with a table. She was added to a virtual court hearing, the medical team asking a judge to order an emergency C-section. Investigative reporter Riley Phillips joins us now after speaking with this mother. And Riley, this case is getting a lot of attention all across the country.
Yes, a court-ordered C-section is not something you hear about often, and this has created a lot of discussion about the procedure and women's medical rights in the state of Florida. Cherise Doyley says she did not want a C-section because of how difficult recovery would be for her, but the UF Health medical team believed her and her baby's lives were at risk.
I love my baby. We're bonded in a completely different way just because of all the trauma that I experienced giving birth to her.
Cherise Doyley's baby girl smiling at her mother behind the camera. Arewa was born on September 9th, 2024 at UF Health in downtown Jacksonville. Doyley, who is a doula and was a mother of 3 at the time, thought she knew what to expect going into labor this time around.
This was the most dehumanizing, scary experience, traumatic experience I've ever been in my life.
Doyley says she went to the hospital feeling excited and ready. 12 hours into labor, though, a nurse brought her a tablet.
I was so afraid, I was confused. I did not know what was going on or what to expect.
Doyley was suddenly on a court hearing from her hospital bed in her hospital gown.
Nah, this is the craziest thing I ever seen.
Doyley's doctor and the UF Health medical team had asked the state attorney's office to file an emergency petition asking for a judge to grant an emergency C-section.
But even to discuss that is crazy without me being notified for me to be able to have my own legal representation. When I'm fine, my baby is fine, and I'm in perfect sound mind.
During the hearing, UF Health Dr. Aaron Burnett says Doyley's labor was progressing slowly, and she was worried about the baby's heart rate and the chance of a uterine rupture. And she says she was concerned Doyley was not going to act in the best interest of her baby.
She made the comment that if her baby dies, so be it. So I think that's kind of what started a lot of this today.
Doyley told First Coast News her statement was taken out of context.
The statement was in regards to if it is my life or the baby's life, the baby is going to have to die. And I stand on that because I have 3 other children that I have to take care of.
But Doyley was insistent she did not want another C-section. She says this would have been her 4th, and recovering from the surgery while also caring for her 3 other children would be difficult.
After each of my C-sections, I was re-hospitalized and I battled infections, and I even had a hemorrhage after my C-section before that. That was 4 years before that.
Doyley asked for legal representation multiple times throughout the nearly 3-hour-long hearing, but the judge said she did not have a constitutional right to counsel. She did have a doula in the room who was able to advocate with her. Under Florida law, the life of an unborn child outweighs a pregnant woman's right to bodily autonomy, allowing for the courts to step in. A spokesperson for the state attorney's office said in a statement, quote, UF Health alerted the state attorney's office that a 41-week full-term baby was facing grave risk of death without medical intervention. The mother was refusing that care. In accordance with our legal duty, our office brought the matter before the circuit court, which held an evidentiary hearing. The statement goes on to say the state attorney's office does not make medical decisions. We ensured the court was presented with the facts so a judge could make his determination under the law. Dr. Chandra Adams is an obstetrician and gynecologist in Jacksonville, not affiliated with this case. She says court-ordered C-sections do not happen often.
I've been delivering for over 20 years, never been in that situation. It's extremely rare and uncommon to need to involve an actual judge, an actual court in a typical labor situation.
The UF Health doctors maintained that a C-section was necessary to ensure the health and safety of both the baby and mother. despite Doyley saying the risks of continuing with a vaginal birth were low and she did not agree that this was an emergency. Dr. Adams tells me performing an emergency C-section depends on what's being deemed an emergency, and sometimes doctors make a call before the situation becomes dire. She says the risk of a uterine rupture increases after each C-section because the uterine muscle becomes weaker and may not be able to withstand contractions.
Typically if you've had one C-section before, your risk is less than 1%. With 2 C-sections, your risk is around 1 to 2%. The numbers for above 2 C-sections are not as easily found in the literature because it's not as common to labor after more than 2 C-sections.
Doyley also says she felt uncomfortable as the only Black person on the hearing, even asking for a Black nurse or doctor to see her instead.
It was scary to think that not only was this decision being made by non-Black people, but also 7 males.
After nearly 3 hours, the judge did not end up making a ruling. Instead, everyone agreed to reconvene the next morning, and a C-section would only be performed if something changed with the baby or the mother's health. Later that night, though, Doyley found herself being wheeled into an operating room. The doctors told the court during another hearing that morning that the baby's heart rate dropped and an emergency C-section was performed. Doyley says one of the worst parts was waiting hours to hold her daughter.
I was overwhelmed, right? Because you have me in court to where I can't even sit up in this bed, and you want me to relive the trauma of everything that you guys put me through that day before, and I still have not been able to see my baby. It felt very intentional. It felt like they were trying to punish me for standing up for myself.
Over a year later, Arewa is still smiling, happy and healthy. But Doyley says she feels violated.
This is not just a simple disagreement between provider and patients. This is about bodily autonomy and women having the right to choose, the right to say no, and informed consent.
I reached out to UF Health Jacksonville for more information. A spokesperson said they cannot comment on any specific patient without consent. Dr. Adams says having some sort of patient advocate in the room for situations like this could be helpful moving forward.
I think there's an opportunity there for hospitals to have advocates who are designated for obstetrics, because beyond just the clinical aspect of obstetrics, there's medical, legal, and ethical considerations too. And so having a specific service with which hospitals could contract to weigh in as intermediaries between the team taking care of the patient herself, and the legal staff there to determine competency for proceeding with labor.
Doyley is now turning her pain into action, demanding change in laws and empowering other women to speak up.
Advocate like your life depends on it, because it does. Your voice matters, your choice matters, and stand up for yourself, right? Do your research and you go in prepared so that you can hopefully, have the birth that you want on your terms.
And Doyley has since created a petition to stop court-ordered C-sections and for UF Health to be held accountable. She says it has over 30,000 signatures so far. Doyley is not the only woman to recently appear before a judge while in labor. Just a year before Doyley, a Tallahassee woman was ordered by a judge to have a C-section. Coming up on Thursday, Arkitha Nelson shares this woman's story and dives deeper into the Florida law that allows this to happen.